Strader versus State of Florida. Both sides ready?
Yes.
You may proceed.
Thank you.
You want to reserve some rebuttal time at the end?
I do, Your Honor. 5 minutes, if I may.
All right.
Your Honor, I'm Ron Filipkowski on behalf of the appellant, Mr. Strader. There's two issues in this case. The first issue is whether the two law enforcement officers who entered his home where the altercation occurred were in the lawful execution of a legal duty when they entered the home. The second issue is whether, when the trial court refused to give an instruction fleshing out what is the lawful execution of a legal duty, whether the jury, that made it impossible for the jury to make that determination without that instruction. The facts of the case are pretty straightforward. Most of them are undisputed, were undisputed in the trial. First is that this is a husband and wife couple that were in a verbal altercation that morning. The wife
The police just sort of happened to be in the neighborhood sort of thing.
they were at the gas station down the road, but it was 9 or 10 hours later when the wife was returning to the property from their houseboat that she went to this gas station and encountered the two law enforcement officers. There's a dispute in the testimony whether she asked them to accompany her to the home or whether they volunteered. I don't think that really matters, but they did accompany her to the home to do what they termed a standby. They conceded that they did not have reasonable suspicion that any crime had occurred. They did not believe that any crime had occurred, but they were going with her to make sure that there wasn't any issues when she got some things out of the home. They asked her to stand at the end of the street by the curb. They approached the driveway. The defendant was inside his garage, inside his home with the garage door open. They asked him to come out to speak to him.
There's testimony of the officers that they had permission from the wife to go inside the house.
Oh, no, Judge.
There's testimony from which that inference can be drawn.
Your Honor, I was the trial attorney. I don't recall that testimony ever coming out in the trial or being in the record that the wife gave them consent to go inside the home.
Okay.
And I will also say that even if she did, the homeowner was there, the husband was there when the wife was not there, expressly telling them.
She was there. She was standing. She was at worst on the curb.
At worst on the curb. They didn't know where she was.
At the property.
Correct. While Mr. Strader was inside saying, "You cannot come into my home. Please leave. Get a warrant."
So I'm assuming counsel for the state's going to contradict you if there is a testimony from which inference could be drawn that she did give them permission to enter the home. Let me ask you this: if from the descriptions the officers gave and from the request that through the officer's testimony, from the request that she conveyed at the convenience store, what do you think would a standby would entail if an officer heard that there was a spouse who was smashing property and the spouse that interfaced with the officers said she wanted to retrieve property from inside the home? Do you think that the officers would reasonably believe they were confined to the curb?
As long as there was no issues and there was no incident. In other words, the smashing of the property had occurred 9 or 10 hours before.
No, but you're saying the request as conveyed by the officers, as conveyed during trial, recounting what they heard from this individual who was seeking their assistance. Is it reasonable for a juror to believe that request would not entail entering the home?
Not if it's a violation of the Fourth Amendment. I mean, it's reasonable for a lay.
Answer. I'm asking you, why would it not be reasonable for the jury to believe that a request for a standby in the context of what the officers heard in the convenience store, that she needed help retrieving belongings that were being destroyed inside the home by her spouse, that request for assistance wouldn't potentially entail entering the home with her or independent of her? I
would think that would have to be a specific request, that she specifically requested her to go into the home at that time with her. Then in that scenario, I would concede that they could, although the other homeowner is denying consent expressly at the time. But that's not what happened here. The wife wasn't standing there saying, "Please accompany me inside the residence." She was out at the curb somewhere and asked them to do a standby. In my interpretation of what that is, and there's no legal standby.
That word
stand by?
She did not. They did.
She asked for assistance, right?
Correct, correct.
She asked for assistance, and then in the course of the discussion between the officer and herself, the officers learned, in addition to the destruction of property, that the husband might have a gun. And I think, at that point in time, when she's asking for assistance to retrieve her items, and if the possibility with the husband that has the gun, and they've got consent for the property and to enter the property. So I'm not so sure about the violation of the Fourth Amendment at that point in time, especially when he's getting argumentative with them and he's refusing to talk to them.
Well, I don't think that there was ever a consent by the wife.
He certainly consented.
They also observed a large bulge in his pocket about the same time, right?
I'd like to address that issue, correct? At the gas,
You need to, because to me, that's a very significant piece of information in this.
that's what the trial court relied on in making its finding, was the bulge. The conversation about the gun was the officers brought that up. This wasn't a situation where the wife says, my husband has a gun. It was the officer saying, are there any guns in the
But in
house?
the minds of the officers, they know that there's been furniture smashed, there's violence in the air, so to speak. He owns a firearm, there's a bulge in his pocket, which could be a firearm.
Well, what they know is that the homeowners own a gun. The wife said she hadn't seen it in years and he did not have it on him that day. So they go to the home, and what they say is when he turns around and leaves to go inside, they followed him inside the home, and yes, they saw the pocket bulge. So the question is there a pocket bulge exception to the Fourth Amendment that would permit a warrantless, non-consensual, and we're arguing that this was non-consensual entry based on that pocket bulge and the idea that the owner of the home
But that would be.
has a weapon?
Just to, sorry to interrupt, but that would be, this argument would only apply if this court found there was no consent.
Correct,
Go
correct.
ahead, sorry.
And I don't think, based on what we have here in the record, that there was consent by the wife in this case to request them to accompany her into the house. I don't believe that direct testimony is anywhere in the record. What is clear in the record is that Mr. Schrader was inside the house telling them, do not enter.
And at the same time, he's saying that and not responding to them to come back out and talk to them, his hand goes on the bulge, right, from the officer's testimony.
One of the officers said that he saw his hand go by the bulge or on the bulge. That is correct.
And it turns out to be his wallet, but he doesn't tell them that, he just carries on.
He was walking away from them inside the garage. Correct. And they followed him in. So the question becomes, in a situation like this where there's no reasonable suspicion, can officers go inside a person's home and place their hands on him, physically restrain him based on the fact that they see a bulge in his pocket while they're having a conversation with him and while he refuses to come out? That's the question. And I think that that's what this case turns on. But of course, yes, if the court finds that the wife gave consent and asked them to come inside, which I don't believe is clear in the record, then that would obviate my entire argument. But I do believe that it's a defense to this charge, which states one of the elements of this charge is that the officers were engaged in the lawful execution of a legal duty. That legal duty must not violate the Fourth Amendment. I believe it's a valid legal defense.
Can I ask a clarifying question? You said that would obviate your entire argument, but I do recall in the brief you said that even if there was consent, correct if I'm wrong, that it would at that point be a Terry stop scenario. And even if the officers had the right to be in the garage, there was not reasonable suspicion sufficient to do a frisk.
No, Your Honor, that I don't recall making that argument in my brief. What I argued was all of the Terry case law. I mean, I believe that the state's position is that they had a right to do a Terry style stop and frisk, and that was essentially the officer's argument at
You're saying
trial.
the state is relying on that in lieu of consent.
Correct.
Okay,
Correct.
what I was saying is if there was consent for them to be in the house, and you're conceding that if that's the case, then for officer safety and safety of all involved, that a frisk would not be violent of the Fourth Amendment.
I agree, Judge.
Can I ask you a question about the instruction? You didn't cite any case law that I recall. You can remind me if I'm wrong, but I was just curious. It seems like I am suspicious that the frequency of this scenario will be high. When I say this scenario, I mean, in a case in which a defendant is charged with assault on a law enforcement officer, I would imagine the frequency, or the percentage of those cases is pretty high in which the scenario is a detention. And the defense would be the detention violated the Fourth Amendment. Yet I didn't see any case law in which this issue arose of requesting and being denied a special instruction regarding the Fourth Amendment, in addition to the standard instruction, which says that the officers must have been lawfully engaged in illegal duty. Did you, I presume you didn't locate any, is that right?
That's correct, Your Honor.
So,
And I did look for that. Correct.
and so I have a question though, so the standard instruction, you're obviously arguing is insufficient.
Well,
But what wasn't, if the standard instruction says they have to be lawfully engaged in the execution of a legal duty, wasn't and didn't you were the defense counsel, weren't you permitted and didn't you take the opportunity to argue that should have been a warrant? I mean, why is that not sufficient? I mean, you have the opportunity to argue there should have been a warrant, they didn't have consent, and why is that not sufficient for the jury to make a determination of whether defense is valid?
it's tough for second-year law students to make that determination. It's tough for lawyers to make that determination. When a lay person has no case law or no law to go by, you say they don't know what the exceptions to the warrant requirement are. I mean, it's not as simple as, do you have a warrant or not? It's the argument of this, the lay person just generally deciding if they think what the officer did is lawful or not, with no law to make that determination. The defense is it was unlawful because it violated the Fourth Amendment, and yet they're provided with no Fourth Amendment guidance, no Fourth Amendment law to make that determination. So they simply substitute their own opinion for what the Fourth Amendment is when they're not provided with any case law. And I think that the special instruction would have made it very clear, these are the exceptions to the warrant requirement, and then you make that determination. Were there exigent circumstances?
Now, the state though said that the special instruction wasn't comprehensive. It didn't include all exceptions.
Well, I think the exigent circumstances was the argument. I
They're
think you have to
say that weren't they going to say the consent was the problem? And you're saying that the special instruction included consent as a potential exception.
And I think you have to tailor your special instructions to fit the facts of the case in any possible scenario. You don't include anything that could remotely, be possible in a jury instruction. It has to fit the facts of the case. I'd also like to talk about remedy as well, because I think that can be a little complicated. I think if you denied the first issue but agreed with the second issue, the remedy's clear, the relief is clear, which is to remand it for a new trial based on the current charges. But I think if the opposite is true, if you agreed with our position on the first issue but not the second, I think it becomes a little more complicated. What the trial court suggested he would do when he was wrestling with this for several hours was that he would essentially direct a verdict or grant the judgment of acquittal on that issue, and it would go to the jury on 2 battery counts. And that's essentially what we'd be asking the court to do if the court granted our request on the first but not the second, is to return this case to the trial court with the instruction that the case move forward on 2 battery charges. And that completes my argument.
Thank you, sir.
Good morning, Your Honors. Counsel, may it please the court. I'm Taylor Schell with the Office of the Attorney General on behalf of the appellee, the state of Florida. Before I start, if I could just answer Judge Atkinson's question regarding the explicit testimony in the record where Mrs. Strader indicated that she invited or allowed the officers to come with her for assistance. It is on transcript page 324. And she says, and I believe it was Officer Jocelyn volunteered. He said, would you like us to go to your house with you and speak to your husband? And I said, sure. Continuing to go on, the prosecutor also indicates that during the stand your ground hearing on that motion, that she had testimony saying, I was really worried because my husband has health conditions, he has heart stents, he's a diabetic, and I just asked, if they could help me. So those are 2 explicit invitations to the house for assistance. When Melissa Strader invited Officer Jocelyn and Officer Ferreira to appellant's house to conduct a standby when she gathered some of her belongings, they had limited information. They knew that the couple was involved in a civil domestic disturbance with verbal arguments and talk of initiation of divorce. They knew that appellant had been at his home breaking marital property, filming it, and sending the videos to Mrs. Strader. They knew that appellant owned a pistol and that he carried it on his person often. And they knew that
Say
Mrs.
often, was that, was the testimony that it was often? I thought she maybe amended that and said not often.
Well, so there's a couple of different testimony that we're looking at. The first testimony was from Officer Jocelyn. Officer Jocelyn testified that the wife indicated that he commonly carried it on his person.
Commonly, okay.
Yes, and then the Officer Ferreira said that his testimony was that the wife indicated that there was a firearm in the home, that it was her husband's firearm, and that she didn't know where it was at the time. Did that answer the court's
Yes,
question?
thank you.
They knew that Mrs. Strader did not feel safe enough in the home to do what she needed to do without the presence of law enforcement there. Acting reasonably, Officer Jocelyn and Officer Ferreira attempted to calmly speak with appellant regarding the civil domestic disturbance. During their interaction, they had a reasonable suspicion to believe that the large bulge in appellant's pocket was the pistol he routinely carried on his person. With Mrs. Strader headed through the front door of the home, Officer Jocelyn took action to conduct a Terry frisk to dispel any concerns that he had of appellant possessing a weapon that he intended to harm his wife with.
Can I ask you about the instruction?
Absolutely.
What, explain to me how the standard instruction was sufficient to inform the jury that about how to decide whether the officers were, lawfully engaged in the legal duty?
Sure, absolutely. So WOOP requires that to establish entitlement to a special jury instruction, the defendant must prove that the special instruction was supported by the evidence, that the standard instruction did not adequately cover the theory of defense, and
So how did the standard instruction adequately cover the jury?
absolutely. So if you take a look, there's a plethora of different instructions, and many of them say the same thing. If we look at the justifiable use of deadly force instruction, and if I may just have a moment, I have all these instructions with me with the appropriate language. So the justifiable use of deadly force instruction, it says a person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. That was the justifiable use of deadly force. The justifiable use of non-deadly force has similar language. And then I think that the most telling jury instruction would be the justifiable use of force by law enforcement officer. And that specifically talks about the execution of a legal duty. If we're looking at the proposed special instruction.
So yeah, I'm wondering what, if the defense is that the duty would have been legal, but for the fact that the Fourth Amendment was being violated, are those instructions adequate to inform the jury of what they need to know to make that determination?
Well, the state's position is that the proposed jury instruction was not an adequate statement of
So
law.
are you conceding that the standard jury instruction was inadequate?
Not at all.
Okay, so then
I
tell
think
me
it was
why
amply adequate.
First, tell me why it was adequate, and then I understand your argument is that the proposed instruction was confusing, or it was under inclusive of potential exceptions to the Fourth Amendment, right?
Sure. This started off as a non-criminal situation. There are a number of different legal duties that are executed by law enforcement officers on a daily basis that have nothing to do with crime. They investigate Baker Acts, they investigate Marchman Acts, they investigate non-criminal traffic infractions, they keep schools safe. Those are all lawful duties that they could be engaged in the execution of, and that wouldn't be included in the special instruction proposed by appellant. What's interesting is that.
So you're saying that it would be confusing because those weren't exceptions as exigent circumstances, consent, et cetera, but they don't include, a little more granular detail about what could bring an officer within the ambit of a home, which would be, for instance, this one, welfare checks, et cetera.
Yes, absolutely, Your Honor.
So again, that sounds a little bit like you're saying that you're not addressing squarely whether the standard instruction is adequate, but you're again focusing on whether the proposed instruction was itself inadequate because it was under inclusive.
No, I think that the standard instruction coupled with the testimony by the officers was more than adequate.
So you're saying, because it almost sounds like you're saying it's adequate because it would just be too voluminous to be comprehensive.
No.
Okay.
I'm saying that there was testimony in the record from both officers regarding their lawful execution of their legal duties that would have described to the jury, in addition to the use of the standard jury instructions, what the lawful execution of a legal duty was. Had appellant wanted to discredit that, because he mentions in the lower court record that he couldn't find any case law, but had he wanted to discredit that, he could have done that through cross-examination using standard operating procedures of law enforcement agencies, et cetera. But he didn't do that. He just went for a special instruction, hoping that that was going to give him what he needed. And again, it's not, it doesn't describe what the lawful execution of a legal duty is. And I believe at the lower court level, the state agreed to the potential for a special proposed instruction, but didn't agree to this one because of the fact that it didn't include all of those lawful execution of a legal duty. If we were at the inception in a criminal case, sure, that would be a better argument, but we're not in the inception of a criminal case. We're at a civil domestic disturbance that turned criminal when appellant refused to speak with the law enforcement officers and they noticed the bulge on his person.
I think you just answered my question, what you were saying of the proposed jury instruction. When there was objection that was raised by the state, there was no amendment proposed. Is that right?
That's correct.
You take this man's ball out of his pocket, you don't have the balls there, different outcome.
Yes, you do. Well, you have the ability for the officers to go and to conduct the standby. And they did indicate that that's actually a majority of the work that they do in Bradenton Beach Police with their 8 police officers on force, that they do hotel motel evictions, that they do civil domestic disturbances. And typically speaking, when officers do that, they ask the party that is in the home to step out of the home for safety of the individual that is gathering their belongings. It's something that law enforcement officers routinely do. The ultimate question for the case at bar is this: what do we as a society expect a reasonable officer to do? Appellant's argument requires this court to find that Officer Jocelyn and Officer Ferreira were not invited to the home. Appellant argues that despite the bulge in appellant's pocket, these officers were required to permit appellant's entry into the home and then must wait until they hear gunshots or screaming before validly entering the home. That is simply not reasonable. Because Mrs. Strader invited the officers to the home before providing them with information that appellant is typically armed, the officers engaged in reasonable actions to dispel their suspicions that appellant was armed with a pistol and headed into the house to harm Mrs. Strader. The lower court's denial of judgment of acquittal must be affirmed.
Well, do you want to address appellant's requested remand instructions in the event that we were to determine that either of the issues on appeal were meritorious?
I don't believe that the record reflects that either of the issues on appeal are meritorious. I would ask that the court affirm. Certainly, the court has the ability to do whatever it would like to do. And if there are no further questions from the court, I would ask that this court affirm appellant's judgment and sentence, and we rest on the merits of the brief. Thank you so much.
Thank you very much. Well,
Thank you, Your Honor. With regard to the consent issue, what the state just read from the record was that the officers at the gas station said, would you like us to go to the house? And she said, yes. That is a huge leap from she consented to have them go with her to her house. That is a big difference between consenting to have them go into the home. Standing outside, we have no issue with that.
But counsel for the state just mentioned some of the issues that she conveyed to them that motivated her request. And wouldn't addressing some of those issues logically entail entering the home?
No, Judge, no, absolutely not. I mean, addressing those issues, what she brought up was commonly carried a pistol, that this man routinely walked around inside his house carrying a pistol. I submit that is not in the record anywhere. What she said is that they owned a pistol and she hadn't seen him with it in a while and didn't even know where it was. That's a big leap to routinely carried it while walking around in the house. What you have here is a situation where the officers were there to make sure she could go in and get her things. But rather than see whether that was viable, they escalated the situation. They wanted him to come out of the house. They ordered him to come out of the house and he refused. And they refused to accept that. And when he turned around to walk away from him, they entered the home without consent, either from the wife or from him. And what the state is asking the court to do is say, if the police officers encounter an individual inside a home who's refusing consent, but they see a pocket bulge, that they are allowed to then go inside the home and physically apprehend that
I'm
homeowner.
not sure that's the argument of the state. I'm pretty sure the argument is that there was judging the evidence in the light most favorable to the non-moving party, that there was evidence from which a jury could infer that the appellant's wife had consented to the officer's entry into the home.
And I just don't, that's nowhere in the record. I mean, she consented to have them accompany her to the home. But I think that giving consent for somebody to enter your residence, particularly when the other owner of the residence is there expressly denying consent, has to be clear and unequivocal. And she never said at the home they could come in. The argument is because she said they could go with her to the house from the gas station, that gave them consent to then enter the home over the other homeowner's objection. That's different from any consent case law I'm familiar with, Your Honor.
So what would happen if she was inside the home and made a 911 call, or if she was on the porch of the home and beckoned to them and they were driving down the road and said, I need some help. I'm trying to get some things out of my home. It's acrimonious. My husband's smashing my things inside.
Well,
What's the difference?
the smashing of the things was 9 hours before.
Which seems to me, I mean, a reason to be that was drawn that could have contributed to her concern that led to her request for accompaniment.
But at the time, the defendant wasn't doing anything violent or erratic or anything. He was standing in his garage. So I think that if that behavior had been going on there at the time, instead of 9 hours before, then there might have been some justification to go in with her. If the defendant was throwing things in the garage, smashing property, yelling and screaming, ranting and raving, making threats, I would agree. But none of that had happened. That was all many hours before. That was in the morning. This was 2 o'clock in the morning.
Videos, I mean, after all that happened, wasn't he continuing to send her stuff?
He did, but that was again, many hours before. This was, the argument occurred at 9 or 10 o'clock in the morning. This was 2 a.m. of the following day. So yes, he was showing videos of him destroying property, which is not a crime, but
And she didn't want to go back home unless she was accompanied by.
well, she never called the police. That's not
Didn't she
clear.
approach them?
What she
They
testified,
didn't approach her and say, hey, what's going on today?
I'm sorry, Judge, what she testified to at trial was that when she entered the gas station, she was not seeking out the police. She went in to get a drink. And then they saw that she appeared upset and offered to go with her.
And their
to the property.
testimony, which
Was
from which we
different.
need To draw any inference favorable to the non-moving party of the state was different.
We concede
She
that.
was approached.
We concede that. Yes, Judge. But I have nothing further.
Thank you very much. Well argued. I think the trial judge said it was a closed case, and I can see why. Final case of the day is State Farm versus Gann.